All right, we're back on the record on State versus Loyd. Who's present with his attorney. State Attorney's Office is present. We're ready to go?
We're ready to proceed, Judge, but we do need, I would ask to approach before the first witness is called
All right,
to
come on
avoid a
up.
later break.
State recognized presence of the jury.
We do, Your Honor.
Defense? Yes. All right, State, you may call your next witness.
State calls Dr. Michael Gamache.
Yes, I do.
Have a seat, sir.
Thank you.
You may inquire.
Thank you, Your Honor. Sir, could you please tell us your full name and spell your last name?
It's Michael Gamache, G-A-M-A-C-H-E.
And where are you currently employed, sir?
I'm self-employed. I'm a forensic psychologist and forensic neuropsychologist.
And how long have you been a forensic psychologist and neuropsychologist?
In Florida, I've been licensed to practice, and I've been doing that kind of practice for 35 years. But I started seeing people originally. I am.
Okay. Can you tell us what you do on a day-to-day basis as a self-employed forensic psychologist and neuropsychologist?
Most of what I do, the vast majority of what I do, is legal cases. Most of them are criminal cases. So forensic is simply a fancy term to say that it's the practice of psychology as applied to legal issues. And most of my practice is criminal cases, especially very serious crimes, sex crimes, and violent crimes. But I also do civil cases and some consulting work of another kind or a different nature.
Now, you alluded to it, but what type of professional work did you do prior to your own practice? If you could just take us through your professional experience.
Sure.
Prior to that.
Sure. So I earned a bachelor's degree in psychology from St. Louis University. I was awarded a National Institute of Mental Health scholarship to pursue a doctoral degree, a PhD in clinical psychology at the University of Missouri, Columbia. I completed those graduate studies, and then I did specialized training in clinical neuropsychology at the University of Florida, Shands Hospital in Gainesville. When I finished all of those things, I decided to pursue a career in research and science of psychology and neuropsychology. And my first job after completing that was as a new faculty member at the University of South Florida. I was an assistant professor in the Department of Law and Mental Health. And then I was also subsequently appointed as an adjunct professor in the Department of Neurology at the College of Medicine. And so I spent about 3 years there on a full-time basis. I wrote several grants, did research, did training for mental health professionals around the state of Florida. And during that time frame, I had started beginning to accept private cases after hours, and that's when I got involved directly in forensic clinical work. I applied for and was accepted to the board of expert examiners in the 13th Circuit, which is in Tampa, Hillsborough County, and I started conducting court-ordered evaluations.
Doctor, you mentioned earlier that you're licensed in the state of Florida. What do you have to do to become licensed as a psychologist in the state of Florida?
It's changed a little bit since I was licensed. It's been some time ago, but at the time that I was licensed, it was largely the same. You had to complete a doctoral level program that was approved by the American Psychological Association. The APA became the accrediting agency for the applied practice of psychology. So clinical psychology involves issues of mental illness, and the University of Missouri had been accredited by the APA for many years before I was a graduate student there. But that's the first requirement. The second requirement is that you complete a minimum of a year of postdoctoral supervised training. I did that, and then you sit for a written examination, and I did that and was awarded my license.
Do you have to renew your license ever, or is it good for life?
Well, every 2 years it has to be renewed, and part of the renewal process involves proving that you have, I have to complete 20 hours a year of continuing education. So by now I have about 800 hours of continuing education. That's all education and courses that I've taken to meet the requirements since I became a licensed psychologist.
What privileges as a professional do you gain from being licensed in the state of Florida? What can you do with that an unlicensed person cannot do?
I guess privileges is one way of putting it. The licensure in Florida relates to the practice, both the practice of psychology and the use of the title psychologist. So you cannot say that you cannot represent to the public that you're a psychologist unless you are in fact licensed as a psychologist in the state of Florida. But the law, basically, it's chapter 490 of Florida statutes. It explains that the licensure is to protect the public. The state of Florida recognized that mental health problems are a serious problem, and that people in Florida that have mental health problems need help for those problems. They need competent evaluations and treatment. And so the state of Florida, like most states, has taken it upon itself to regulate the profession.
So earlier you told us that the overwhelming majority of your work is forensic work.
Correct.
And that the majority of that work is criminal in nature, correct?
That is correct.
Can you give us an overview of what your forensic work in criminal cases consists of? What types of cases you look at?
Well, in terms of the type of charges, as I mentioned, it's over the course of 35 years, I've done every kind of case you can imagine, from misdemeanors to the most serious felony cases. Most of what I do now is strictly serious felony cases, and those are predominantly violent crimes, homicides, aggravated batteries, sexual crimes, and my involvement can be at any stage of the case.
So would that include evaluating individuals for sanity under the law?
Yes, absolutely.
Would it also include competency?
Absolutely.
And would it also include looking at potential aggravators or mitigation in capital cases?
Yes, that is another area where psychological science has some application.
So have you had an opportunity within the last year or two to look at the number of criminal forensic cases that you've worked to sort of see, how often you testify on behalf of the defendants or criminal defendants on behalf of the state?
Yes, I did have the opportunity to do that. I did it specifically to respond to a question during a deposition, or I knew that that was going to be a question, so I got together with my assistant. We don't keep a database of that, but in order to be able to be responsive during the deposition, we just calculated like the last 150 cases that I either had pending or that I had completed.
And can you tell the members of the jury what your split between state and defense has been over the course of those last year or two?
It was 52% of the cases I'd been retained by defense attorneys, and 48% I'd been retained by prosecutors.
Now, have there been occasions during your forensic career where you reached an opinion after being hired as an expert by the state that was unfavorable to the state's position or their prosecution?
There have been a number of times, whether I'm hired by the defense or hired by the state, that my opinion is not perceived as necessarily supporting the posture of that party.
In fact, can you tell us about the first post-COVID case that you recently testified in, and if it fit that description?
Well, in that case, I was retained by the defense, and I testified at a jury trial with regard to the issue of insanity or sanity at the time of the offense. I can't keep all of these cases in mind, but that one is distinctive to me because it was the first time I had testified in person again in front of a jury since the onset of COVID.
Now, have you previously been asked to provide opinion testimony to a jury in the field of forensic psychology or forensic neuropsychology in the past?
Yes, I have.
And do you know approximately how many times you've provided such opinion testimony within the courts of the state of Florida?
I do not have an exact number. I can try and give you an estimate. I've been doing this for 35 years. I didn't testify quite as often in the first few years of my career, but on average, it's about 60 to 75 times per year, sometimes more than that, sometimes less than that.
Has there ever been an occasion where you were asked to provide opinion testimony but were not permitted to do so because your qualifications were not sufficient?
No, I'm grateful. Every single time I've appeared to testify, I've been determined to be qualified to offer an expert opinion.
And you have been previously retained by the Fifth Circuit of the state of Florida, and specifically myself, on other cases besides this case. Is that right?
Yes, you or other prosecutors in the Fifth Circuit have retained me before.
Now, your work in this case, State of Florida versus Markeith Loyd, came at our request. Is that the state attorney's office? Is that right?
That is correct.
Now, we asked you specifically to evaluate the testimony of a defense expert, Dr. Toomer. Is that right?
That's correct. You asked me to consult with you and the state regarding his testimony and his opinions.
And how much do you charge per hour for the forensic work that you do?
$250 an hour.
And do you know approximately how much you've billed the Office of the State Attorney up to today for your work in this case?
I don't know up till today, but up to the mid-October, I had billed for 80 hours or thereabouts. I started working on the case in November 2019, and so before my deposition with Mr. Lenneman, I'd gotten together with my assistant, and we'd figured out how many hours I'd billed for already.
Now, I specifically asked you about your role in evaluating Dr. Toomer's testimony. Can you explain to members of the jury how your role or what the work you do changes depending upon the type of opinion you're being asked to give in a criminal case?
Sure, yeah. It seems like a subtle distinction, but it is useful to know about. So if I'm hired by a defense attorney and the referral question from the defense attorney is, my client is charged with such and such, and I'm concerned about whether he might have a defense or she might have a defense of insanity. When I'm hired by the defense and I start reviewing the records, and if I evaluate the defendant, I'm in the position of generating hypotheses. In other words, I'm coming into the case fresh. Nobody else has necessarily given an opinion. I'm going to review everything there is, and I'm going to consult with that defense attorney. I'm going to generate hypotheses, and I'm going to consider those hypotheses in relation to the legal question in the case and share my opinion with the defense attorney. By contrast, when I'm hired by the state, I'm not, and when I'm hired in the state in particular in an issue of insanity at the time of the offense, I'm not so much generating hypotheses, but instead I'm testing hypotheses that have already been generated. So in this particular case, when I was retained by the state, the defense and the defense expert, specifically Dr. Toomer, had generated some hypotheses. And when I agreed to be retained, it was for the purpose of testing those hypotheses. So my agreement with the state is I'm going to look at anything and everything that is potentially important. I'm going to look in particular, of course, very carefully at Dr. Toomer's work and his opinion, and I'll tell you honestly and truthfully whether I think it's supported.
Or sustained.
I will tell you whether I think it is supported or it is not supported. And that's exactly what I did in this case.
Did you, therefore, have a chance to review the deposition that the state took of Dr. Toomer prior to your testimony today?
Yes, I did.
Did you also, just this weekend, have an opportunity to review Dr. Toomer's testimony from the witness stand in this case?
Yes, I did.
Could you tell the members of the jury, and if you want to use some general terms to describe, because there's a lot of documents, what other materials you reviewed in preparing for your testimony and reaching an opinion in this case? There was a massive amount of material, but I'll try and just give you the categories. The categories included the discovery, the police reports and related documents, legal documents pertaining to this particular case. The discovery, the legal documents pertaining to the case of Ms. Dixon. It included the reports in many instances and the testimony in many other instances of various expert witnesses that have previously that testified at the previous trial that evaluated Mr. Loyd. It included transcripts of testimony of lay witnesses. It included medical records and psychological or psychiatric records pertaining to Mr. Loyd. It included jail and prison records. It included some raw test data from evaluations that had been done previously, including the evaluation by Dr. Toomer. I think I've covered the major areas. I may have forgotten a couple. I can look back and be more specific if necessary. No, sir. I think you covered it. Did you also conduct an interview with the defendant, Markeith Loyd?
Yes, I did.
And that occurred on September 10th of this year, is that right?
It did.
Was it video recorded?
It was, the entire thing.
So was you previously, well, do you know if Dr. Toomer did an interview with Mr. Loyd?
I understand that he did.
Was that video recorded to your knowledge?
I understand that it was not.
Do you know how do you know what Dr. Toomer heard from Mr. Loyd during his evaluation?
The sources for that would be three off the top of my head. One would be that Dr. Toomer either provided directly to the state and they provided it to me, or Dr. Toomer provided it directly. I don't recall as I sit here today. Notes from that were purported to be from his examination. I read Dr. Toomer's deposition taken by the state where he was questioned about the examination or the examinations, and the third source would be his testimony.
Now, do you agree with Dr. Toomer's conclusion that Mr. Loyd was insane at the time that he killed Lieutenant Clayton? Just generally, and then we'll talk more specifically.
No, I don't.
Now, could you inform the members of the jury what the legal criteria for insanity are within the state of Florida? And before you do that, would a diagram help you do so?
Sure.
And may I approach the witness to what's been marked and shown to defense counsel as State's Exhibit BU?
You may.
Dr. Gamache, I'm handing you what's been marked as State's Exhibit, or I'm going to show it to you. BU, do you recognize that?
Yes, I do.
And how do you recognize it?
It's an exhibit that I have prepared for use and application in insanity cases.
Does it, in your training and experience, accurately represent sort of a roadmap of the law of insanity within the state of Florida?
It does. I've found it useful.
And at this time, I'd ask the court to admit State's Exhibit BU as the next numbered exhibit.
Any objection? All right, this will be received without objection as State's Exhibit number 63.
permission to publish State's Exhibit 63, Your Honor?
You may.
So, Dr. Gamache, we can do this one of two ways with the court's permission. I can put this easel here and sort of turn it so that everyone can see it, and I can hand you a laser pointer, or if you'd like to step down and the court permits, you can step down and go through your explanation that way, however you'd like.
It makes, maybe the easiest, I probably don't trust myself with a laser pointer, so
You can step down, Doc.
Thank
I'll
you,
step
Judge.
down.
So the specific question, and I'm actually going to ask you, yeah, if you could stand on that side, that way we don't block any of the jurors. Hold on. They're going to hand you a microphone because nothing's easy in this courtroom. So the specific question I had, Dr. Gamache, was could you explain the law of insanity using your diagram to the members of the jury?
So the black box with the white print at the top is the actual statutory language that comes from Florida Statute 775.027. And down below it, I've tried to lay out kind of a decision chain for how I, as a psychologist, not a lawyer, but as how I, as a forensic psychologist, apply findings from psychology to the legal criteria. And so what I often refer to, and that many other experts refer to, as the A prong for establishing a defense of insanity.
Sustained.
So could you tell us about the first prong of insanity under the law in the state of Florida?
The first prong of insanity is that it must be established that the defendant suffers from a mental infirmity, disease, or defect.
And what is the second prong of the insanity defense within the state of Florida?
What we refer to as the second, or the B prong, has two elements to it. The first element is, as a result, if the defendant does in fact suffer from a mental infirmity, disease, or defect, does that mental infirmity, disease, or defect, is it of a nature, is it of a magnitude such that it would affect their cognitive abilities, their thinking and their reasoning, so much so that they don't know what it is that they're doing when they commit the crime, or they can't comprehend the consequences that may come from what they're doing.
Well, so they don't know what they're doing or the consequences. Is there a third aspect that is a possibility?
There is, because even if it's established or even if it's accepted that they meet the A criteria, they have this mental infirmity, disease, or defect, but the data doesn't support that they didn't know what they were doing. In other words, the data and the evidence suggests that they did know what they were doing, and the data and evidence suggests that they knew what the consequences were. You could still support a finding of insanity if, even though they knew what they were doing and knew the consequences, they didn't appreciate the wrongfulness of what they were doing.
So on your diagram, there's a stop sign up the top right stop sign. Explain what that means to the members of the jury as it relates to prong A.
Well, logically, if the evidence in the psychological data doesn't support the conclusion that a defendant suffers from a mental infirmity, disease, or defect that's capable of interfering with these cognitive functions, then you can stop there. They don't meet the A prong. The B prong is only relevant, or the second prong is only relevant if you can adequately establish the A prong.
So you have, is my understanding that a defendant has to meet both prongs of the chain that you just described in order to be determined, or for you to render a conclusion that he or she is legally insane.
They must meet the A prong, and they must satisfy either the first part of the B prong or the second part of the B prong.
Okay, thank you, Dr. Gamache. You can have a seat again.
Great, thanks.
That's going to block my view of you from there. So now let's, if you don't mind, turn back to Dr. Toomer's opinion that you were asked to evaluate. Were you able to determine which mental illness, disease, or defect Dr. Toomer believed Mr. Loyd suffered from as to the A prong?
I could not determine that with certainty.
And can you explain to members of the jury why that is, why you had a difficult time determining that?
Well, the two fundamental sources of information I had to enable me to understand that and interpret that were Dr. Toomer's deposition taken by the state and his testimony on this past Saturday. And when I read his deposition and I consulted with Mr. Williams, I explained to Mr. Williams that
Without saying what you said,
Sustained, yeah.
without saying what you said to me, walk the members of the jury through the process.
So I carefully reviewed the deposition. I identified each of the parts of this deposition where Dr. Toomer was asked a question about his opinion with regard to what mental illness or mental defect that Mr. Loyd suffered from in January of 2017. And the deposition reflected testimony from Dr. Toomer regarding multiple conditions, including schizophrenia, delusional disorder, post-traumatic stress disorder. The deposition might have included bipolar. I don't remember that, but I remember him saying that on Saturday. And so it was difficult for me to determine with certainty from his testimony exactly which condition he believed, or which conditions, it could be more than one, that he believed that the defendant was suffering from on January 9 of 2017, and how any of those conditions affected the defendant with respect to those B-prong criteria.
So you referenced January 9, 2017 on a couple of occasions. You probably made this clear, but why is that a significant date in your analysis?
Well, it's sanity at the time of the offense. That's the date of the offense.
Why is it important to be able to identify or if established, multiple specific mental illnesses in support of an insanity defense?
Well, if I'm going to test a hypothesis that another doctor has generated, one of the ways that I approach testing that is if they identify a particular mental illness or mental defect that they say existed on that date, one of the things that I'm going to do as I look through all of the records, as I consider all of the information, all of the data, all of the testimony, is I'm going to try and compile a list of things that are consistent with the diagnostic criteria for that particular condition. So if it's schizophrenia that is being purported to be the mental illness that a defendant suffered from on the date of an offense, then I'm going to be carefully going through all of the material I have, and I'm going to be looking at the diagnostic criteria for schizophrenia and trying to identify any and all of the diagnostic criteria, that is to say, any and all of the signs and symptoms of schizophrenia that might have been present, in particular on the day of the offense. But because schizophrenia is a chronic condition, I'm also going to pay attention to any evidence at all that the condition existed prior to the offense and continued and was active on the day of the offense.
Now, are you aware of anywhere in any of the testimony of Dr. Toomer that you've reviewed where he specifically examined the diagnostic criteria for any of the mental illnesses that he opined Mr. Loyd suffers from?
My understanding from his testimony is that he did not do that.
Now, you used the word diagnostic criteria on a number of occasions, and you sort of explained it. Is there a specific text where you find those diagnostic criteria?
Sure. In the United States, for mental illnesses, The specific text that those of us in psychology and psychiatry and other mental health professions rely on is the Diagnostic and Statistical Manual version 5, or the DSM-5 for short.
Now, who publishes that text?
That's published by the American Psychiatric Association.
And what does the 5 stand for?
It's the 5th revision of that text.
And how is it put together or its content generated?
It's a compendium that is the work of panels that specialize in different areas. So, for example, schizophrenia and psychotic disorders is one of the general classifications of the types of different disorders. And so there is a panel and some sub-panels with respect to each of the different diagnoses or each of the different conditions that fall under the schizophrenia spectrum. And those panels are responsible for reviewing the scientific literature, reviewing the history of the DSM and how that condition has been addressed diagnostically, determining whether any revisions are warranted to the diagnostic criteria, and then making their proposals to the larger committee that is comprised of the editors of the DSM-5.
Does the DSM-5 address the significance of having one manual with specific criteria and why that's important in your field of psychology, or specifically forensic psychology?
It does address that directly.
Can you tell the members of the jury why that is and how it addresses that?
It put most succinctly, the authors and editors of the DSM-5 say, look, the benefit of relying on these
Sustained. Rephrase.
I'll just ask, why is it significant or why is it important that the DSM-5 exist and have specific criteria that are normalized across your field?
To improve the reliability and validity of making a diagnosis.
So did you utilize the DSM-5 when conducting your, or when doing your work in this particular case?
Yes, I did.
And how did you go about doing that? How did you use it specifically in your work?
How do I use it specifically in my work, or how did I use it in this particular case?
In this case. I'm sorry. Thank you, sir.
So in this case, once I had had a chance to review all of the records that had been provided to me and had a chance to review Dr. Toomer's deposition and his raw data, in part because he had identified a number of different conditions that he said he thought existed in Mr. Loyd at the time of the crime, I decided to take the strategy of working backwards, so to speak. And what I mean by that is that the common denominator for, in fact, it's part of the definition of a mental illness in the DSM-5, is that not simply that a person have some signs or some symptoms, but they have a constellation of signs and symptoms.
Sustained. Just rephrase the question.
So when you said you worked backwards, what were you looking for specifically as to the diagnoses that Dr. Toomer provided?
What I was looking for specifically is evidence that whatever the condition might be, that it affected his functional abilities, that he was in some way disabled by it, that it was clinically significant. That's the common denominator of mental disorders.
So explain that. When you said that there are indications or people can have signs or symptoms of mental illness, but that's not sufficient in and of itself?
Not in and of itself, no. In fact, that's a part of the diagnostic criteria. People can present with different signs and symptoms, but is the constellation of signs and symptoms of sufficient magnitude and seriousness that it's somehow disabling to them?
Okay. Now, did that approach, the working backwards as you described it, impact the way in which you conducted your evaluation with Mr. Loyd?
It did.
So can you tell members of the jury how you used that approach and how it played out in your evaluation with Mr. Loyd?
So I wanted to know ultimately I wanted to get inside of his head for January 9 of 2017. But before I got to that, I wanted to work through the process of understanding his functioning in the community in the time frame from 2014, when he returned to the community, up until December 2016 and January 2017. So I spent considerable time speaking with Mr. Loyd, questioning him and understanding, what did he do when he got back out? Where did he go? How did he function? Was he able to take care of himself? Did he pay his own bills? Did he take care of himself? Did he have a place to live? Was he able to communicate with people, develop relationships? Those are all the functional activities of a day-to-day life that we're all engaged in. People that are seriously mentally ill will have problems, will have difficulties, sometimes disabling difficulties in one or more of those areas. So the concept here was to work from when he got back out into the community and explore his functional capacity for that period of time, from 2014 up and to and including January 9 of 2017, because that would give me a clue. If I learned about different functional impairments that he had experienced during that time frame, then I would follow up with questions about, if you couldn't work, what was the obstacle? What was the problem? People wouldn't hire me because I wouldn't show up, or I wasn't taking my medication, or what have you. But again, the point was to work systematically through these functional activities, his abilities and his capacities in the community leading up to the day of this particular offense, as a way of understanding and evaluating, did he have a genuine serious mental illness? And if so, in what ways was it disabling to him? And how was that disabling aspect relevant to his thinking, his emotions, and his behavior on January 9 of 2017?
Do you feel you had the sufficient ability to, through your conversation with Mr. Loyd, gain an appreciation of his functioning during that time frame?
Yes, I do.
Can you give us a sentence or two as to your opinion as to Mr. Loyd's ability to function during the time frame that you've described?
I found his functioning, his capacity for functioning in these day-to-day domains to be, in fact, exceptionally good, not disabled. He was very effective. He was very much of an entrepreneur, and a successful entrepreneur from a work standpoint. When he got back out to the community, when he left the community, there was no such thing as Facebook. When he got back out, he discovered Facebook, and he was a prolific poster on Facebook. Not only that, he learned to use it to stay in touch with old friends, new acquaintances, to make friendships, to express himself, to read about the thoughts of other people, and in particular to engage in finding prospective relationships with women, which was a very important part, a very strong and important motive for him in his life.
Now, based upon your conclusion about Mr. Loyd's functional abilities from 2014 up through the time of Lieutenant Clayton's death, did you form an opinion as to whether or not Mr. Loyd suffered from a mental illness or disease and the A prong of the insanity defense?
Yes, I did.
And can you explain to the members of the jury what your opinion is as to the A prong?
All right, my opinion is, and in the way that it relates to those functional abilities, my opinion is that there's no evidence that he suffered from a serious mental illness at any point during that, what are we talking about, roughly 2-year time frame. No matter what whether the argument is it was PTSD, whether the argument is that it was schizophrenia, whether the argument is that it was bipolar disorder, all of those conditions are known to result in significant functional disability. for people. He didn't have any functional disability, so there was no real basis, and he certainly had not been diagnosed or treated for a mental illness during that time frame. So there was no basis, in fact, to conclude that he met the A criteria, or the A prong for defensive insanity.
Now, you were discussing, you use the phrase signs or symptoms. Is foaming at the mouth a sign or symptom of mental illness?
It is not. I'm glad you asked me that. I heard that testimony, and I can comment further on that if you like. Yeah, so when I heard that, I recognized that it was being offered as obviously as a lay perception that Mr. Loyd must have been mentally ill, or even specifically, I think the testimony was psychotic at the time. And I know as a practicing psychologist that the first three things that come to mind when you hear foaming at the mouth are an overdose of drugs, a seizure, or rabies. Psychosis is not one of those things. Foaming at the mouth is not a symptom of, it's not a psychotic symptom. Psychosis isn't a diagnosis, and it's not a symptom of a specific type of psychosis, such as argued in this case, schizophrenia.
Now, initially, Dr. Gamache, did you form or reach an opinion as to the B prong of the insanity defense?
So what I told you and Mr. Lenneman at the time of my deposition was that I'd not bothered to take that step, and I explained that there were a couple reasons why I had not at that point, but since then I have.
All right, and what information allowed you to reach that second prong conclusion or opinion that you received after your deposition but before your testimony here today?
In particular, it was the testimony of Mr. Loyd himself, and to a lesser degree, the testimony of Dr. Toomer.
So can you tell the members of the jury what it was about Mr. Loyd's testimony on Saturday that leads you to a conclusion as to the B prong or B prongs possibilities of the insanity defense?
The thing that struck me the most, and that I was able to directly correlate with something that I had interviewed him about, was the way that he described his reasoning, his thought process, and his moral compass, if you will, in January, and specifically on January 9 of 2017. And it reminded me about something that I had interviewed him about and that we had a very interesting discussion about. And that's something that you heard some testimony about as well, and that was specifically Mr. Loyd's decision to acquire guns and ammunition during this time frame between 2014 and 2017. And I knew about that. I knew he had done that.
Sustained.
Can you tell the members of the jury what it is about Mr. Loyd's decision to obtain firearms during that 2.5-year time frame that is relevant to whether he knew the consequences of his actions or that they were wrong?
When I spoke with him about that, and I inquired directly about his reasoning and his thinking and how he made the decision about that, and it was very clear. His reasoning was, I know it's wrong. I know it's against the law. In fact, he intentionally didn't tell his probation officer for that very reason, but morally, he justified it to himself. And part of the justification was he didn't want to stop working at Texas Chicken, where he says he was making $1,000 a week. And so what he described to me was kind of weighing the balance. I don't want to give up this good paying job. I know what I'm doing is wrong in the legal sense, but I'm going to justify it in my own head. I'm justifying it as an appropriate thing for me to do, even though it's wrong legally.
So what is your final conclusion as to the B prong of insanity as relates to Mr. Loyd as of January 9th of 2017?
It's effectively the same thing. I have no reason at all to doubt that Mr. Loyd appreciated that what he did was legally wrong. Now, He justified it in his own mind. He engaged in his own personal calculus about what was important to him. And I gather what was important to him.
Sustained?
I'll just ask you a last simple question, Dr.
Sure.
Gamache. Based upon your conclusions on both A and B prongs, do you have an opinion, or can you tell the members of the jury your opinion as to whether or not Mr. Loyd meets the legal criteria for insanity in the state of Florida?
If I'm asked to render an opinion about that, my opinion would be no, he does not meet the legal criteria.
That's all I have, Your Honor. Thank you, Doctor.
Cross?
Yes.
Good afternoon, Dr. Gamache.
Good afternoon, Mr. Lenneman.
We know each other because over the last 8 years, you've testified in several of my cases for the state of Florida when they were seeking death. Is that correct?
I don't know that every case was a death case, but we've met before, and some of them were capital murder cases, yes.
So Vernon Stevens was one of them. Remember that? Vernon Stevens.
I recognize the name, I can't recall the case.
And the other one was Byron Birch, B-U-R-C-H. Is that correct?
Apologize, it sounds faintly familiar, but I don't remember the case.
Now, you consider yourself a very good psychologist, do you not?
Yeah, I think that's a fair statement.
And as a matter of fact, in your profession, to keep work flowing freely, it's important to do a good job for your clients. Isn't that right?
So when you ask me if I consider myself to be a good psychologist, I say that because I really focus on trying to do a good job and doing quality work, yes.
And as a matter of fact, you indicated the work you do for both the state and the defense is evenly split. Isn't that true?
That's correct.
And wouldn't it be fair to say that in 2015, you had approximately 50 to 75 death cases that you had worked on up to that point, and you indicated it was kind of like a 50-50 process on those. Is that right?
You know, I don't recall that. As a ballpark figure, that might be right, but I don't recall that. I don't recall testifying to that. And I don't know off the top of my head.
And you'd agree with me that you want to bring the best of you to the table when you are testifying for whoever you're testifying to, right?
Doesn't matter who I'm testifying, who's called me to testify. I definitely want to do a good job. I want to do a quality
And
job.
as a matter of fact, you want to make sure that there's no possible conflict that's going to interfere with your ability to testify. Isn't that right?
Well, I typically, when I get a new referral, will check to make sure that I don't have a conflict in the case, yes. That's a routine part of my practice.
If I can have a moment, Judge, I'm sorry. And isn't it true in your career, doctor, that you have worked for a great number of law enforcement agencies?
I have. Well, to be clear, I haven't been employed by them, but I've done consulting work for them.
Okay. And we're talking about more than 10, is that correct?
I don't recall the exact number, but at one point I had contracts with a number of law enforcement agencies.
And as a matter of fact, FDLE brought you in to help them solve cold cases, isn't that right?
I consulted with FDLE. In fact, I was the principal investigator on a research project to evaluate psychological factors relevant to serial murders, serial lust murders, and serial rapes.
And you worked for the U.S. Marshal's Office, is that right?
Again, I had a contract with the U.S. Marshal's Office, and I did consulting work.
And you contracted with the Pinellas County Sheriff's Office, is that right?
I did.
And you contracted with the Tampa Police Department, is that right?
I did.
You contracted with the Hillsborough County Sheriff's Office, is that right?
Yes, I did.
We already talked about the Florida Department of Law Enforcement. And there were a handful of other agencies besides the 6 or 7 we just talked about that were smaller than that, correct?
Some of them were smaller. There were a couple other larger ones.
Okay. Now, I noticed when you were testifying, you indicated that when you're going through your records, there was no indication that you received Facebook pages. Is that correct?
I'm sorry, are you saying as I testified today, there was no indication I'd seen Facebook pages?
Well, you went through everything you reviewed, and
Okay, so you are talking about today. I understand your question now. And so that was simply an omission. I reviewed a large amount of media, specifically or particularly Facebook postings by Mr. Loyd.
Okay, and so you know there was approximately 30,000 pages of Facebook in this case?
You know, I heard you say that on Saturday. I don't honestly remember, but I know it was a huge volume.
Okay. And it was a mistake that you kind of overlooked the fact that you had reviewed Facebook pages?
Not at all. I was asked, I think, to be succinct and not itemize everything, but that's certainly an omission, and thank you for pointing that out.
And when did you receive those Facebook pages?
I don't know the exact date. I know that I've been working on the case since November 2019, so it certainly would have been between November 2019 and earlier this year, but I couldn't tell you off the top of my head exactly when.
And you're aware that when I took your deposition, I was emailed a copy of all the records that you were provided. Is that correct?
Are you talking about the email that I sent to you?
Well, it's originally dated December 29, 2019, correct? That's the one you forwarded?
I don't have it in front of me. I've got it with me. I don't have it in front of me, but you were provided with 2 itemizations of the documents that I reviewed. One came directly from the state, and the morning that you took my deposition, we had prepared one of our own and sent it to you and to the state.
And did you review the one that I got from the state?
I did not.
Would you like to review it?
It's entirely up to you.
I just want to ask you if you see Facebook on there. I'll approach the witness, Judge.
You may.
Doctor.
Thank you. No, if this is the itemized list that the state provided you, I don't see it on there, but it is on my list.
Okay. And your list is prepared by who?
By me.
Okay.
Well, by me with the help of my assistant. Okay. She catalogs every document as it comes in.
And that was, if you compare that to any other part of these documents in terms of the volume, that was pretty much the largest volume, correct?
Yes, that's a fair statement.
And you understand that these Facebook pages contained a number of writings, hundreds and thousands of writings of Mr. Loyd. Isn't that right?
That's correct.
And in those writings, he talks about the police, he talks about race, he talks about white America, all throughout those. Isn't that correct?
All of those things and more, but those are some recurrent subject areas.
And
I
in
paid a
your
lot of
opinion-
attention to that.
I'm sorry. I mean,
I simply said, and I paid a lot of attention to that. I thought it was important in this case.
well, I didn't hear you mention it being important. Is there a reason why you didn't bring up? Because obviously you prepared for your testimony.
Absolutely.
You're very good at what you do.
Thank you.
And so you even prepared this chart to show the jury how much you know.
I did not prepare it to show the jury how much I know. I had prepared it probably a year ago in another case, and I've shared it with attorneys, both defense attorneys and prosecutors that retain me, as a potentially useful diagram for understanding how we apply the process.
And those would be in the realm of the 35 to 40 times that you worked for the state in a death penalty case. When there was the issue of insanity and they hired you on that, that's what you used, correct?
Well, the statute hasn't changed that I can think of during the entire 35 years that I've been doing it in Florida, but as I just testified, that is a illustration that I only prepared about a year ago.
So when you did not talk about the Facebook page postings, was that something you discussed between you and Mr. Williams?
Well, your question includes the predicate that I didn't talk about it. Actually, I'm pretty certain I talked about it during the deposition that you took of me. I certainly talked with the state about it, and I'm happy to talk about it today. I think it's important. I apologize, I did omit specific reference to that when I was just trying to give them a quick outline of what I had reviewed.
Because unlike you, Dr. Tuma relied heavily on those Facebook pages.
To the contrary, I found them to be incredibly important, and I'm happy to explain why. I think it's useful for the jurors to know why. May I?
Well, let me ask you, can you tell me, Doctor, what is a delusional disorder?
Sure. A delusional disorder falls in, there are different categories of disorders. One category is thought disorders, and it's referred to now as the schizophrenia spectrum. Delusional disorder is one type of schizophrenia spectrum disorder. And I can describe the distinguishing characteristic of it if you like.
Well, isn't it true that it's a false fixed belief that are held despite incontrovertible evidence to the contrary?
Okay, so that's a different question, actually. So there's a distinction. It may not be obvious to you, but it is important to understand. So the DSM-5 includes some fundamental definitions that are relevant to mental disorders. Delusions can be experienced in response to more than one type of disorder. Delusional disorder is a specific diagnosis where the primary symptom, in fact, the only symptom, is a delusion or delusions, plural. But the definition of delusion isn't part of the diagnostic criteria per se. I think you read it. It seems I don't remember word for word what you said, but I think you left out an important part of it. It's a fixed, false belief that is adhered to despite what the evidence would seem to indicate, that is not shared by a subset of the population that you identify with. And I'd be happy to give you some examples, including specifically how that's relevant in Mr. Loyd's case.
Okay. And you stayed away from that in your testimony because you don't have to admit that you don't find, at least in terms of the belief that law enforcement is trying to kill or was trying to kill Mr. Loyd, that's a false fixed belief, correct?
I'm sorry, I did not follow that question. Maybe if you could restate it.
You looked through, you claim, Facebook pages, is that correct?
I'm testifying under oath. I studied the Facebook pages that were provided as part of the evidence in this case.
Well, let's talk about that for a second. We'll
Sure.
get back to the false fixed belief. Isn't it true after you study everything, you have a meeting with your captains, people who pay your bill, and you tell them things like, well, here's the advantage of me evaluating Mr. Loyd, here's the disadvantage. Isn't that right?
I would disagree that they're my captains. They don't directly pay my bill. The state of Florida does, but I certainly confer with them and consult with them about what my opinions, my preliminary opinions are based on review of the records and the pros and cons of conducting an examination of the defendant. And it's the very same kind of consultation that I do with defense attorneys.
Well, isn't it true that you do that before you go to talk to Mr. Loyd? You did that before you went to talk to Mr. Loyd?
I did do that before I went to talk with Mr.
And
Loyd.
you explain to them what is the pros and cons of you going to evaluate Mr. Loyd?
Yes, I did.
Because they make the final decision, right?
That's important to understand. I don't get to decide anything specifically about what I do. It's up to the attorneys that retain me.
So in other words, if you as a doctor want to do something and they say you shouldn't, does that mean you can't or you won't?
Well, it doesn't happen very often, but if I suggest to an attorney, whether it's a prosecutor or a defense attorney, that I think that doing something, either doing a particular piece of research or doing a clinical interview of a defendant is important, and that in fact it's crucial to the case, and they say, well, we're not going to allow you to do that. I mean, they have the right to do that. They also have the right to limit my testimony when I appear. There have been occasions where an attorney might say, no, I don't want you to do that. And my response is, well, you know, I think that's so critical that I'm not comfortable going forward if you don't want me to do that.
And in this particular case, there was a decision made that you were being hired specifically, as you had said on direct examination, to test the hypothesis of Dr. Toomer. Is that correct?
That's correct.
So you went into this situation with the goal of testing the hypothesis of Dr. Toomer.
That is correct, and that's what I told the state, that the examination could potentially aid me in advising them about whether Dr. Toomer's opinions and conclusions were supported or were not supported.
Okay. And before you watched Mr. Loyd testify on Saturday, you didn't test the hypothesis of Dr. Toomer. Isn't that right?
That's not correct. That's inaccurate.
Well, you said what was important to you was, in addition to his deposition, was his testimony at trial.
That's correct. I did say that.
And when did you watch his testimony at trial, Doctor?
On Saturday.
So on Saturday, when we left each other in deposition, you had said you only addressed prong one of the evaluation. Isn't that true?
I think I'm either confused by your question or I'm not sure about the time frame. You asked me when did I listen to the testimony of Dr. Toomer, and I said Saturday, meaning just this past Saturday. You and I haven't seen each other until today.
Exactly. So when you came in and gave the deposition on...
You're referring to when we sat out in the hallway then?
No, I'm referring to October 6, 2021. Right. Remember that deposition?
Yes.
Okay. And isn't it true that you told me in that deposition that you only addressed prong one and didn't go any further, correct?
That as of the date of that deposition, I had only formulated an opinion and shared it with the state about the first prong, that is to say, whether Mr. Loyd suffered from a mental infirmity, defect, or disease on January 9 of 2017.
So as of that date, you hadn't even looked at prong 2, is that correct?
Well, I had, in fact, attempted to look at it, but I was obstructed in doing so.
When you say you were obstructed, and we were going to get to this, but I'll bring it up. You did an evaluation of Markeith, isn't that right?
I did.
Now, you said Dr. Toomer's evaluation wasn't videotaped. Is that correct?
That's what I was told, yes.
But both you and Dr. Warner's was.
I don't know about Dr. Warner's.
Do you know why yours was videotaped?
Well,
Objection as to the relevance of that question.
Sustained?
We've had conflict in the past. Isn't that true, Doctor?
I want to answer that in the most professional and tactful way. You have been difficult to deal with.
Okay. And you kind of think when you get involved in the case, you're like the third lawyer on the case. Isn't that right, Doctor?
I've never thought that. And I've never gotten any feedback from anybody that thinks I act like a third lawyer on a case. I'm not a lawyer, to be clear.
Okay. As a matter of fact, in 2013, when we were preparing for the penalty phase of Vernon Stevens, and the court had...
Objection, Your Honor. Relevance and it's not in discovery.
Sustained.
Have I videotaped you before, Doctor? In your evaluation of my client?
I don't recall.
Now, it's your opinion that Mr. Loyd has a long-standing fixed belief that law enforcement are racist, that the criminal justice system is racist, that people that are not the same skin color as him are racist.
Objection. Compound question.
It's one...
Sustained.
You would agree with me that it's your belief that you think Mr. Loyd has a long-standing fixed belief that law enforcement are racist?
Yes, it's my opinion that Mr. Loyd has long believed that law enforcement is racist.
A fixed belief?
It's been long-standing, so it seems to be relatively fixed, yes.
And as a matter of fact, you believe that Mr. Loyd believes that the criminal justice system is racist?
He does. He believes the criminal justice system is racist and corrupt.
And you believe that Mr. Loyd has a fixed belief that people that are not the same skin color as him are racist. Is that right?
Yes, that's true. It's reflected in both my interview with him and in his Facebook posts.
But although you think he has a fixed belief about that, you don't believe that he has a fixed belief that the police were trying to kill him.
No, I don't believe that he has a fixed belief that the police were trying to kill him specifically.
You actually believe that this belief, you don't find it fixed, but this belief is reasonable because Mr. Loyd, based on the circumstances he was in, should have been concerned about the police killing him.
So if you're talking about that specific belief and the belief that he was at risk of being killed by the police on and around January 9, 2017, I believe that he did perceive that risk, and it was a rational perception on his part. He was wanted as a suspect in a murder, an attempted murder. He was on the run, and he was very acutely aware that he was considered armed and dangerous. And that creates a potentially very risky and volatile situation.
Isn't it true, Doctor, that when we were talking about this long-standing fixed belief regarding law enforcement, isn't it true that you don't believe that's delusional in part because there are subsets of the culture that we live in have the same belief that he identifies with? Isn't that right?
Not simply because there are subsets of the culture that share that belief, but because he identifies with some of those specific subsets, including the sovereign nation, the people that believe in the sovereign nation, the black nationalists, and in particular, Black Panthers, and several other groups that share the same kind of fundamental beliefs and thoughts. In fact, he even uses language or phrases or shorthand from some of those different subsets in the things that he does and in the things that he says or in the things that he writes. While Mr. Loyd, make no mistake, he's an independent thinker, he's not the type to really affiliate closely with one particular group. He's not afraid to borrow thoughts and ideas. And that's the fundamental distinction here. That's why it's my testimony that Mr. Loyd doesn't suffer from a delusional disorder. He doesn't suffer from delusions. He has these fixed beliefs. They relate to corruption or racism that's systemic in our country, and that he relates to the history of slavery. And that's not uncommon at all. In fact, it's particularly prominent these days as there's been more sort of tribalism and talk and publicity about those kinds of things. But it's been around quite some time. And those Facebook posts, contrary to your questioning of me, I considered them extremely important. This is something that has evolved in my practice of psychology. Years ago, we might occasionally encounter cases where somebody had left behind a diary. That would give us a window into their mind, into their thinking, in their emotions. These days, with the internet, lots and lots of people record their thoughts, record their emotions, record their beliefs on a daily or nearly daily basis. It's new material, it's important material, and it's significant material, particularly in this case where Mr. Loyd talked at length for 2 years about these kinds of thoughts and beliefs. They weren't disabling to him. He found other people that shared the same thoughts and beliefs, but not everybody acted the exact same way that he did. It's not a delusion when it's something that is widely shared by a subset of the population. I can give you a couple other examples of that go outside the specific ones that pertain to Mr. Loyd. Other cases that I've evaluated that have similar fixed beliefs that many of us might consider to be false, but they're not delusions, and they're not the product of a mental illness.
Now, you had a 4-hour evaluation of Mr. Loyd, didn't you?
4.5, something like that.
It was videotaped and transcribed.
Yes, it was.
You had an opportunity to read the transcription?
Yes, I have.
Where in that 200 and 14-page document is a single question about Facebook to Mr. Lloyd.
Is this copy indexed?
It is a
That'll make it
copy. It's not
faster
indexed.
for me to... Because I don't recall from memory. This is not indexed.
No, I understand that. I'm asking you.
Okay. I couldn't begin to search through all of this at the moment. I've got notes that I made from the transcript. It might be reflected in there.
Please.
But we definitely talked about it.
So check your notes.
Okay.
Did you provide those notes to me?
I just made them when I went through the transcript to prepare for testimony today.
Okay. Well, Judge, I'm asking for, Judge, can we come sidebar on that while he looks?
Sure.
Shall I continue to search for that?
Did you look in your notes?
I did.
Do you see any reference to them in your notes?
I have them right here. I'm happy to share them with you, but I don't see specifically the word Facebook in my notes, but I distinctly recall talking to him about the use of it, and I can give you an example of that.
Well, I'd like to see it on paper, because an example is that you're stating it without support. That supports the entire evaluation that you had.
I'll look for it, given that it's not indexed. It might take me a minute. I don't want to
All
delay
right, folks,
things.
this seems like a good time for you all to take a break while the doctor looks through his notes. So why don't you guys take your afternoon break? Thanks. All right, folks, everyone can just be at ease while the doctor looks through his notes, and then you all can look